Okay. Are you ready, Natalie? Okay. All right. So we're back on the record, and we've got everyone present. And we left off in Ms. Suriel's testimony, and I'm going to assume, Mr. Rusumano, you received what you were requesting?
I did. Mr. L sent it to me in a PDF. Thank you very much. I did look at it. And I just have a few questions for Ms. Suriel before I'm done asking her some questions, if that's with your honor. Ms. Suriel, isn't it true that you were an employee at will at the Simon trial firm?
At will, I'm sorry?
Yes, an employee at will. Florida law provides employees, it's an at will state. It's true that you were an employee at will, correct? Meaning you can leave anytime you want and Mr. Simon can fire you anytime he wants, right?
Yes.
Okay. And isn't it true, I know you had testified earlier about your salary. Isn't it true that in the year 2013, you were paid approximately $340,000? 2018, approximately $340,000 as a 4 to 5 year lawyer you were testifying about.
And that year, that might have been, I don't know the exact numbers, but my base salary was under 100 grand.
Right. No, let me ask you the question again. So my records show that total, it's $340,000 between your base salary and your bonuses. Is it your testimony under oath that that's not the amount of money that you received?
No, that might be accurate, but then the year following that or prior to that could have been lower. That might be it. I'm not sure. I don't have my taxes in front of me.
And you testified earlier about the other charging liens that the Simon trial firm has asserted in numerous cases. Isn't it true that in the majority of those liens, your firm or your clients have not paid out those charging liens to the Simon trial firm?
No, that's not true.
Okay, how many charging liens approximately have the Simon trial firm asserted in all the cases? Litigation and pre-lit, how many?
I don't know, in the 28 maybe?
Okay, let's assume your number is 28. Out of those 28, how many liens have you paid the Simon trial firm? Your client or you? How many?
That we've actually paid out, the ones that have been adjudicated. Right. This would be the third. I mean, it's on the Simon firm to pursue its lien. I'm not just going to pay out for my clients absurd amounts. Out of those 28, I think only 4 or 5 actual attorney's fees liens have been disclosed. Only costs have been disclosed to my firm, and they've been agreed to, undisputed costs.
Isn't it true that despite the undisputed costs, you have not paid the Simon trial firm its costs in all those charging liens as of today, correct?
Herman, I received an email from you after last week's hearing, finally, with the totality of all the costs, and my firm is under review that, and we've been adamant that it's undisputed since I left the Simon firm. So I'm not sure what the line of questioning is trying to get at, and I don't think that is relevant here at all.
Next question, it's still unclear to me. Is the Simon trial firm's lien in this case, the case that we're here for today, is that money being paid out of your client's net amount or out of your attorney fee? It's still unclear to me.
As you know, per the law, it comes out of the client's net amount. It's the client's responsibility to pay both their prior attorney and their new attorney.
So you're making your client pay 2 attorney's fees, the Simon trial firm's fee and the client's fee? Is that your testimony?
I'm not making my client do anything. I'm following the law on the topic.
Okay, because I wanted to be clear, because earlier in your testimony, you made it sound like, and you said to his honor, that it's almost 95% of the attorney fee, 80% of the attorney fee. You've said that on a couple occasions, which to me, and that's why I wanted to clarify, it made it seem like you were insinuating that the Simon trial firm's lien was going to come out of your cut, your firm's cut, but you're saying that's not true, correct?
No, it's not true. And any indication of what that percentage is just to show how unreasonable the charging lien is in this case for the facts present in this matter. And that will be highlighted in the presentation, the demonstrative aid that you saw.
When the plaintiff retained your law firm and terminated the Simon trial firm's services, did you explain to the client that by terminating the Simon firm and retaining your firm, that under the law, that the client be paying your fees plus the Simon trial firm's fee?
Yes, I explained it, and that is also explained in the joint letter we sent out when I left the firm. So the client was very much aware of their responsibility under the law.
Okay, so your testimony is that the client's going to be paying out of the client's net settlements, whatever his honor awards. I understand that. And do you have a retainer agreement or a closing statement or anything in writing that confirms that the client is going to be paying this fee instead of it coming out of your net amount of your fee?
I don't have any agreement as to that I'm aware of, but in the closing statement, it very much highlights and reflects that any pending attorney's fees provided by this court and ruled upon will be owed by the client.
Okay, so now that I understand that it's your client's net amount that's going to be paying the Simon trial firm's fee. Okay, just to be clear, your fee is not going to be affected by his honor's ruling here today or whenever his honor makes a rendering, correct? Your firm's fee.
No, my firm's 40%. You'll see it in the chart of what it is, the reasonable amount. This whole lien is to prejudice the client. And you're very much aware of this before coming to this hearing. This has been the same position the firms have taken in every charging lien we've had. And this has been communicated to you via email. So it's not anything new, that based on the case law, when a client leaves a firm, and this is, I think you have an exhibit regarding the joint letter that was sent. When a client leaves a firm, they are responsible for those fees. That is of no secret. That is what the law is.
And yeah, you're correct. You have done this on numerous occasions, right? In the other cases, you've also had the client pay Mr. Simon's firm's fee and your fee out of the net settlements, correct?
Yes, I think you're beating a dead horse, Herman. There's no secret about that.
I'm responding to your comment about prejudice. And wouldn't you agree with me that it's prejudicial to a plaintiff in a personal injury case that you not satisfy the Simon Charles firm's fee out of your fee versus requiring a woman who presumably in this case was injured, received the settlement amount, who now has to pay two fees by changing law firms from the Simon firm to your firm? Wouldn't you agree with me that that's prejudicial to your client?
No, what I think is prejudicial is the Simon firm continuing to demand unreasonable amounts, whether it comes from the attorneys or whether it comes from the client, despite knowing the work it's put in here. And I don't think it's prejudicial for me to, on a pro bono basis, defend my client's position to minimize what the lien is and give a reasonable amount to the Simon firm. And whether there is a reduction in my fee out of the goodness of my heart, if that's what I want to do, that's between my client and I, and that would be after any hearings. But at this juncture, given what the law is and what your understanding of what it is as well, is that yes, it does come out of the client's cut.
Your client's not here to testify in opposition to the trial firm's fees, correct?
No.
Okay, and your client has not submitted any sworn affidavit, declaration, or any evidence at all in opposition to the Simon trial firm's fees, correct?
My client has adamantly, through pleadings, disputed this, and there's no need for her to have to give a sworn affidavit in that regard.
Okay. Your Honor, I have no further questions for Ms. Suriel. I do, well, I'll wait for Ms. Suriel to close, but I just want to let Your Honor know that based upon the testimony that she gave, I do need to briefly call Mr. Simon in rebuttal, if that's permissible with Your Honor, to address certain points.
All right, well, let's okay, you can reserve that right. And Ms. Suriel, again, technically, it's redirect time. Is there anything else you want to say?
No, Your Honor.
Okay, I just have a couple of questions. If I understood it, the net settlement or the total settlement amount was $86,000. Is that the correct number?
That's correct.
And what was your fee?
The fee is 40%, which is the 34,400.
But in your cross-examination, there was a demarcation between the lien fee, Mr. Simon's firm's fee, and then your fee. And your fee, and am I understanding you to say that your agreement led to a fee calculation of 40% of 86,000?
Yes, the attorney's fees collected on this matter overall are 40%, which is 34,400 of the 86,000.
Yeah, but that's, and maybe I'm misunderstanding everybody here. The theme of the cross-examination at the end there was, and it led to some confusion, and that's why I want to clear it up in my mind, is that he was insinuating or suggesting that $86,000, what we're doing here is we're taking 40% for the new Suriel firm, and his original fee agreement was a third or 40% after filing, right? So he's suggesting, Mr. Russomanno, with his questioning, that there was basically the potential for two fees here for the client. And I'm just wondering what your fee was, just so I can fully understand that. And it's
right.
If you're telling me, if I'm understanding you correctly, you're saying it's the Suriel law firm takes the position, which is really not before me, that you're entitled to 40% of $86,000 in fees.
Right, and that's what the case law would have, and that's how I responded to Mr. Russomanno. The case law is that the person who changes attorneys, and that's what's explained in the joint letter, would have the responsibility of paying both attorneys to the prior attorney in a quantum merit analysis.
So are you, see, that's a different evaluation then. So in other words, are you, at the end of the day, and I guess we could maybe clear this up in closing argument, but is it your position, Ms. Suriel, that whatever ruling my math here, and you said it earlier, is that 40% of 86,000 is $34,400?
Correct.
And what I'm understanding you to be saying during your examination here a moment ago is that 34,400 is the fee, and for the Suriel firm, and that leaves 51,600
right
left, and that whatever the charging lien amount to be determined under the theory of quantum merit here, that comes out of the 51,600, not out of the 34,400.
That's correct. That's what the quantum merit analysis is, and that's what the case law shows. Whether at the end of the day I decide to reduce my personal fee to give my client an equitable result here would be out of the goodness out of my heart, but that's not what the law holds. But I do want, if I have the opportunity in closing, that's why I did the demonstrative aid that was going to walk through all those exact numbers that your honor is questioning, to shed some light.
And then I had one other question for you, and that was, we were throwing out attorney fee numbers, hours, and rates, and ultimately, do you, and it might be in your document that you've given to him that you'll show me in a bit, sounds like it probably is, what is your number that you're asking this lien be assigned? Do you have a
yes
number?
Yes, which it's going to be part of the closing, but the total number, it comes out to $8,918.75.
Okay, all right. Okay, thank you very much. Do you have any further evidence, Ms. Suriel?
No.
All right. So you suggested the prospect of rebuttal. Is that what you wish to do, Mr. Russomanno?
Very, very briefly, Your Honor, Mr. Simon, just to rebut some of the comments that Ms. Suriel said.
Mr. Simon, would you raise your right hand, please? Do you solemnly swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
I do.
Okay, and tell us, we have the same court reporter, but tell us your name again, please.
My name is Ronald Mark Simon, Your Honor.
Okay, go ahead, Mr. Russomanno.
Thank you, Your Honor. Mr. Simon, very briefly, I just want to touch on a couple points. You heard Ms. Suriel just testify that her client, the plaintiff, is scheduled to pay Ms. Suriel 40% of the net amount, plus whatever his honor awards as your charging lien. Can you please explain to the court, in your 40+ years of experience in personal injury law, what the common practice is amongst lawyers when one lawyer's firm is terminated and the second lawyer's firm is hired? How do you treat the client in terms of how they pay that fee?
Respectfully, Your Honor, in my 47 years of practice, I have never heard of an attorney leaving a firm where they are employed, taking a case that was not brought in by them to themselves and strapping that client after they settle it with 2 attorney's fees. I have never heard in my life of practice where a lawyer would put 40% to line her own pocket, the full contingency fee after the case being with another law firm for 3 years, put that full 40% in her pocket, and then tell the client they're going to have to pay me for my work for the first 30 months. That is not morally, ethically, or under any possible terms of my education experience, anything I can imagine being done. That prejudices the client. Ms. Suriel testified that the bar letter that Mr. Rusomano created for me, which we always send out so the client has a choice, the bar regulates lawyer conduct. The Florida bar has its letter to go out because the one thing the Florida bar wants to do is make sure that the client's interests are above those of attorneys. There is nothing in the Florida bar letter when a client leaves a law firm, nor in the letter that Amanda and I sent out, Your Honor, that indicates to the client that they're going to have to pay her 40%, whether she does 2 minutes of work when they leave the firm or 5 years, and then pay my 3 years. Nothing in that letter says that. To the contrary, it does not say that. So that is not the standard practice. It's shocking. It's prejudicial. And I'm surprised at this. And I'm surprised now I know why we're here. That's not the standard in this community. I do not see anything. This is an elderly lady, as Ms. Suriel pointed out. This was not her client. It was my client. She didn't have the education, knowledge, or experience to even sign something like that to inform the client that this would happen. The client's not here to even testify that she knew this. I'm sitting here not understanding how in her own, and she's a fine lady, it's not personal, great lawyer, no problem with that. This, however, is not something I've ever heard of to do to the client. The client of the 51, since Your Honor brings it up, that's what's left to the client after Ms. Suriel has already put her money in her pocket. But the 51 is not left. The client still has to pay the costs, which he's agreed to pay because there's no reason not to, which I've not received. But there are also medical expenses. Those come first. Our firm always protects the medical liens and pays the client's obligation on letters of protection or Medicare liens to the doctors and physicians prior to the client receiving money. I don't know what those are or what they're outstanding because she has not produced a closing statement for you, Your Honor, or any of us to look at. But I would venture to guess that with medical expenses to be paid out of that, the client would net nothing or might even owe money. So in answer to your question, Herman, this is something I've never heard of, and I'm not sure, how to handle that in this instance until I've met Ms. Suriel.
The testimony that you heard earlier from Ms. Suriel about her role in the firm, can you explain to His Honor very briefly what you and her did together on each and every case, specifically your review of pleadings and filings as they go out?
I'm going to object to the form and line of questioning. This is not rebuttal. Mr. Simon had his opportunity to give a testimony in their case, and he could have talked about his timesheets and what he alleged in there, and he failed to do that. And I don't think it's appropriate to now just bring it up as a rebuttal.
Okay, overruled, but you're going to have a chance to cross-examine if you wish. Go ahead.
I'll be very brief, Your Honor. Ms. Suriel is everything she said she was. She came in here and did a wonderful job in the management of the practice. But in 47 years, she knows and I know that I'm the captain of the ship. The Florida Bar makes me responsible for the conduct of everybody that works here. Because of that, and because it's the right thing to do, and because I've been a sole practitioner from the day I left law school, I've never had but one time a partner of interest. So it's my own practice, and it was at the time she's been with me. I oversee the work, the substantive work of each and every lawyer, including Ms. Suriel. So to cut to the chase, every single complaint that goes out from this office, including this one, were either created by me, discussed with me, or approved by me before it went out and or after. Every single answer to discovery my eyes have seen, I have reviewed, I've discussed with Ms. Suriel. I supervised her work. She knows that. If you look at the pleading that's there, my name is the name on the pleading, on the complaint. I do that work, and I don't allow things to leave my office unless my eyes have seen that. As far as the meetings, we have weekly meetings where all of the cases and strategies are discussed, including this case. None of that appears on the time record. So to make it appear that I'm sitting here as a fat cat on my desk having nothing to do with these cases was just simply false. I pride myself in my work. In regards to the value of her services, she will tell you, I'm sure under oath, that each and every case she handled up until the time she left, I am basically the one who settled those cases, closed those cases, were there at the mediations. I was on the phone with opposing counsel. I have relationships over 30 years with opposing counsel, including the ones on this case who I talked to many times. And that's how those cases get ended. She does pleadings in practice. I assist her with the strategy, and we discuss them in meetings. She's in my office constantly, to her credit, asking how to handle these things. That's how we operate, and that's why we were successful together, and I offered her a partnership because of that.
Your Honor, just a couple more questions for Mr. Simon. Mr. Simon, is it true that your law firm paid Ms. Suriel in 2018 approximately $340,000 between her salary and bonuses?
Yeah, at the time she left, her salary that year was $134,000. I checked the figures, and she made $193,000 in bonuses. Actually, it was $197,000, so it was $340,000 that she received as compensation, in addition to health insurance and other things that we paid for her.
And Mr. Simon, I'm going to end with this. In regard to the charging liens, and I've been your counsel for years, and we issued charging liens in all of the cases in which Ms. Suriel, when she left, and she took cases with her, approximately 28 to 30. Would you agree with me that of all those charging liens, the only ones that have been paid are the ones that we have to force to go to court and get a judge to order upon?
Sadly, it's the truth because of I believe this is because of the route that she's taken to put my charging lien in the client's pocket, instead of doing what all other lawyers who I know that practice in the majority of cases, but for exception, pay out of their own fees so the client doesn't suffer. That's why I believe we're here.
No further questions, Your Honor. Thank you.
Ms. Suriel?
I'll cross-examine. Mr. Simon, isn't it true that on this specific case, just as of last week, you rejected taking 40% of my attorney's fees?
I would object to this as confidential.
Sustained.
Okay, so isn't it true with regards to all the other charging liens that are pending that your firm has refused to come to an agreement where it can be resolved based on a percentage?
I have no idea what you're asking me. I'm sorry. You're talking about other cases where we have charging liens?
Yes, you just sat here before the court and explained that unfortunately your firm has to litigate 20 other cases because I've been unreasonable in trying to award a percentage of my firm's fees to your firm, which in fact is the opposite. Isn't it true that my firm has made offers to globally resolve all the matters for a percentage, as opposed to having to litigate them individually?
I understand now. I'm glad you asked the question, and I'd like to explain. Your Honor, most respectfully, under the Florida bar rules, lawyers who have cases removed from their practice can pay out to the lawyers 25% of the total fee. It's standard practice. In fact, Your Honor, the truth is that I pay 25% attorney's fees out to lawyers who refer me cases who do absolutely no work. If you sign a bar agreement, you sign a retainer agreement, and your client signs off on that in the beginning of the case, knowing there's going to be a split to a lawyer who does no work, that lawyer can still receive a 25% referral fee. I have from the beginning on these pre-litigation cases said, look, Amanda, we had a relationship. You worked here for years. You took cases of mine that were not your clients. Fine. You know what? Even though I've done a lot of work on those cases before you left, I will be more than happy to accept 25%, the same amount of money, Amanda, that you're paying people who've done no work to refer you business right now. And you have rejected that. So I hope
Your Honor, I'm going to strike the response as unresponsive. I want to be very clear.
You have an objection, and I'm going to sustain that. It's become obviously a little personal. And so I'm just going to ask you to ask the next question, okay?
Okay. I don't have any further questions, Your Honor. I'll just reserve for the closing. Thank you.
Any redirect, Mr. Russomanno?
No, Your Honor. Thank you.
Any further evidence, Mr. Russomanno?
No, Your Honor.
Okay, the evidence is closed, and ready to hear your arguments.
Thank you, Your Honor. May it please the court, Your Honor's paid great detail to the testimony and the evidence, so I'm not going to rehash everything. I'm going to summarize it for purposes of the record and for Your Honor.
Can I ask you a question before you start that? Did you go into mediation on all this, on all these cases and these liens?
We have, I don't think we mediated. Amanda, you can correct me if I'm wrong, but I don't dispute that we have been for 2 years trying to resolve everything globally. And to this date, it has not occurred, Your Honor. And unfortunately, we've had to go to fee hearings, which both parties have the right to do.
I get it. I'm just really kind of more curious than anything else. If I'm understanding your math, this is number 3, and there's a lot left.
We had 4. We had an arbitration and 3 fee hearings. This is our 3rd fee hearing. Both sides are spending a lot of time and money on it. The economics of it, I don't need to explain. But we need to get them adjudicated. Otherwise, the checks don't come, period. So that's what we've had to do.
Okay. I'm just wondering, I mean, would it maybe not be in everybody's interest to sit down with all these, with somebody like
Of course it is, Your Honor. And I think, my office has definitely tried with Mr. Russomanno. And I think that the reason why I bring up the percentage of what the attorney's fees are now at my firm and what Mr. Simon is asking for, which is 95% when we started the hearing, and now they're down to, I think, 80%, is incredibly unreasonable, and why I've been dragged into this position. So
obviously the positions of everyone are they've narrowed a little, of course, since we began this hearing, but there's still, you all are on different islands, if you will, in terms of your positions on the equities of all of this, and even the numbers and whatnot. And I'm just, as a more than a casual observer, I'm obviously the intermediary who's going to have to decide it. And I could look at it and just say, put the blinders on like a horse in the horse race, and just focus on my case. But just kind of wondering, really, is it maybe not in everybody's interest for one of these judges, like maybe this one, to say, why don't you go to mediation, folks, and see if you can work all this out before I make a final ruling on this? Because it just seems, like.
Well, Your Honor, in all fairness, I think enough time and expenses have been at least expended from my office in this matter. Mediation would just layer that. After I've even hired counsel to try to handle this, as a, an intermediate from me with the Simon firm, and that also didn't resolve anything or get us any closer to it. I know Mr. Simon just gave a lot of testimony as to what's common practice in his 40 years, but I'll tell you, my short time of being an attorney, especially in personal injury, it's definitely common practice that, like he was throwing around the 25% referral, that when a client switches, that the attorney prior just take a third or less of what the total amount is, especially when a case still requires litigation and work to be done. But that's what's common practice, and that's not what's happened here. Not in this case and not in any of the other cases.
I understand. So, it's really kind of throwing out the possibility. I mean, and there'd be more expense, of course, but there's going to be more expense in time. I mean, are you going to do this another 28 times with other judges, traders? I mean, why doesn't everybody kick in, split up a day's worth of a mediator and get somebody who's, well versed in the economics of personal injury cases and see if you can sort it out? That's just a thought I had. No one needs to answer that right now. It just was triggered by curiosity and somewhat of a feeling of potential obligation to maybe helping you all shepherd this to a conclusion. But be that as it may, I interrupted Mr. Russomanno, and I'm going to hear his argument, and I'm going to then hear Ms. Suriel's argument, and then we'll see where we go from there. Okay.
It's a good question, Your Honor, and thank you for asking it. I think what we've had to do, and Your Honor mentioned the blinders, and I could tell you we've done this 2 times before, and some of the issues is that this money's coming out of the client's pocket. So the other courts and this court, and Your Honor, is to look at the Searcy case and make a ruling not based upon the fact that this money's coming out of the client's pocket or that this money may be coming out of Ms. Suriel's pocket in the future, but strictly focused on whether the amount that's being sought is reasonable based upon the lodestar and the Searcy factors. And I can represent to Your Honor, and I know the other side doesn't agree about the reasonableness, but there is no dispute, practically, no matter what case you've ever litigated, that 30 months of work of 52.77 hours, averaging 1.75 hours a month, is unreasonable. And it's exactly the opposite. And Your Honor is well aware, Stuart Williams, very well-respected attorney in South Florida, has testified as the expert to opine upon that. And in fact, his testimony was even that there were even some entries that were underbilled. So we could be asking for, meaning the Simon firm, could be asking for much more than $27,000 that we're asking Your Honor to enter. And that's not the case. We're asking for the amount that was spent and the amount that was incurred based upon the hourly rates. And we respectfully submit that the number that Your Honor should award is $27,418.75. And the specific lodestar is identified in great detail in the amended Exhibit 10, which I submitted to Your Honor. And it's very simple. It's 52.75 hours. Amanda Suriel's managing partnership hourly rate of a lawyer making $340,000 a year of $475 an hour is reasonable for 34.9 hours. Mr. Simon's rate, which has already been, and Your Honor's going to make his own ruling, Mr. Simon's rate, which has already been approved, and there's no dispute, he's 47 years trial lawyer, one of the best slip and fall personal injury lawyers in South Florida, if not in Florida, $800 an hour at 11.3 hours. The rest of the hours are not being disputed. Ms. Suriel testified that the other 3 lawyers at $275 is undisputed, and their hours, which are nominal compared to the other ones, but we're not here for that. So in the end, $27,418.75 is the amount that Your Honor should award. Clearly, the case law will support that award. The Searcy case, the factors of the Searcy factors, and I repeatedly did this on purpose on the record. The Simon firm was not terminated for cause. I've done many other fee hearings for other law firms in South Florida where we have that for cause issue, which then substitutes and subtracts the amount. We're not dealing with that here. It just didn't happen. And I can tell you that the plaintiff is not here to testify or oppose the fees the plaintiff is paying, not Ms. Suriel. So, and that's why I asked her that question, because if it was Ms. Suriel's testimony that the money was coming out of her fee, then obviously her entire testimony is biased. because it's coming out of her pocket. But the fact that the plaintiff is paying for it, which is every right, and I agree with Mr. Riel, the case law, and this is why Your Honor made the blinder, Your Honor has to apply the case law, which is the Lubell case out of the 3rd DCA. No one disputes it. And that the client pays this fee if Mr. Riel is going to get her whole fee.
What is that case? Just
I'll give you the citation, Judge, and I could email it to you, but I did.
just give me the site. You don't need to.
Yeah, I'll give it to you. And Mr. Riel, I've used deny in other cases. It is.
It's really more curiosity than anything else.
Hold on. I have it here. It's 3rd DCA.
I can find it just with the name. LUB.
I'll give it to you. Hold on, I have it. I promise. All right, it's 901 Southern 2nd 951. And the case law is clear that if the client's told that they got to pay 2 fees, which is why that's why I asked that question and redirect or recross of Mr. Riel, the client needs to explain, hey, if you want to jump ship to the second firm, although you're leaving one of the best firms, you have every right to hire Mr. Riel, but you're going to end up paying 2 fees, then God bless you, and you go for it. That's what the case law says. So no one's disputing that Your Honor can award every penny of $27,000, and it will be affirmed because it's a reasonable fee because it's only 1.75 a month. So there's no concern about reasonableness, and the case law supports Your Honor doing it. So there should be no consideration, and I don't know what I'm going to hear in closing, but there should be no consideration as to it's too much money or it's unreasonable or it's not fair the client pays 2 fees, because that we're here. This is what it is, and that's what the law provides. So that amount should be awarded. And there is no expert testimony that's been presented by the other side to rebut Mr. Williams. None. The plaintiff didn't come here and say, I oppose Mr. Simon getting fees, because according to Ms. Suriel's testimony, she said she explained this to the client. So eyes wide open. Client went in eyes wide open, and they have to pay the $27,000, which you think is fair and reasonable. And I'll just reserve a couple minutes for any rebuttal, Your Honor, but I think it's clear. The evidence submitted before you, and Mr. Simon testified to every entry that he performed. That's his firm's. And Mr. Williams attested to it as an expert, period. So $27,000 should be awarded by this court, Your Honor, from our perspective.
And to remind me, I have notes here, but it was that was inclusive of the agreed upon amount of costs in the amount of $2,493.94.
Exclusive. So the fees, and it's Simon's amended Exhibit 10, which should be in your CMS.
I have it here.
That's our lodestar to the penny. That's it.
And I should have looked at that bottom line.
It's okay. It's okay.
All right, I got it. I'm with you. All right, so that's exclusive. This number is exclusive of the cost. Okay. Thank you, Mr. Rusomano and Mr. Riel.
Oh, Your Honor, sorry. I apologize. I also need to ask Your Honor, pursuant to the Treviso Supreme Court case, which is in your CMS, which I provided to counsel last week. Supreme Court says that pursuant to the Florida statute, expert witness fees at the discretion of the trial court may be taxed as a cost for a lawyer who testifies in an expert. Because we were forced to come have a hearing on this issue, and Mr. Williams, I specifically asked him on purpose at the end, how much were your fees? And he testified to, and I have it written down here for purposes of the record, Mr. Williams testified that he had spent 13 hours of time, $500 per hour, which is $6,500. And also under the Supreme Court case that I cited, we respectfully request that Your Honor award that amount as well.
Okay.
All right, Your Honor, I'm going to put up the PowerPoint, if I may share the screen at this point.
Yeah, I think I already authorized you to, so go ahead, give it a shot.
Can everyone see the presentation?
Yeah.
Okay. Okay, as Your Honor can tell from the testimony I presented and the presentations from both sides, but I've given a lot of detailed analysis and consideration to to the Simon firm's allegations here to ensure that everyone is properly accounted for and to assist the court in making an equitable decision. Under the quantum merit and the law that applies, this court is sitting in equity. And it seems, though, that the Simon firm's goals with its timesheets and its presentation has been quite different. And it seems that there is a constant theme here. And the theme seems to be inflate everything, then concede some and appear reasonable, or confuse everything, then distract the court from the actual applicable standard here. Note that despite knowing that its bills were contrary to the statute 57-104, which was put into evidence by the Simon firm, and the applicable case law, and knowing what the expert's opinion was going to be, and knowing what the expert opinion has been in other cases similar to this one, the Simon firm, just the evening before the hearing, decided to still actively allege 118.4 hours and demand it of bills that included 70 hours of clerical work. Now, if their own experts said they're reviewing the timesheets based on the Youngblood case, which I had provided to the court thinking I was going to have to rebut that, their own experts said that he couldn't find out one of those entries to be non-clerical. And that all those purely clerical things had to be taken out. So now that just starts giving the court a flavor of why we've been unable to resolve this matter. Because just the evening before, there was $33,000 being demanded as a reasonable attorney's fees here. And that's outside of the cost. And then keeping in the theme of appearing reasonable, the Simon firm attempts to make this argument that, well, 53 hours divided by a span of 3 years, blah, it's almost nothing per month. Of course, there is no mention of the 10 months that the case was completely idle while at its firm. And most important, it's also being completely ignored that the quantum merit analysis does not ask the court to take X amount and divide it by X time. In fact, if we continue to quote the Cersei case, which is a case where entitlement was disputed, and it is not like this case, but if we take away the nuggets that Mr. Russomano wants us to consider as totality of the circumstances, then what we have to look at here is if the Simon firm's been able to prove every single hour it's claiming, and it has failed with its burden, it has failed. And according to the law, I provided this case for your honor, the Brake versus Murphy case. While the proof by way of contemporaneous records is not imperative, something more than wild guesses are necessary to support an award of fees based on reconstructed records. And Mr. Simon's testimony here failed to give a viable explanation of how his office came up with the actual time entries and how it came up with the suggested hourly rates. And likewise, Mr. Simon's testimony failed to provide any support for what his actual work was that he did on the file. And an award for attorney's fees must be supported by the attorney's testimony who performed the services. Okay, the opinion of an expert witness does not constitute proof about the facts necessary to support that conclusion. And here, if it were not for my personal testimony on behalf of my client's position as the lead attorney working at the file, while the Simon's firm, the charging lien for the Simon firm itself will be void of the requirement that the working attorney speak as to what is reasonable in the hours. Okay, so when we're talking about value of the case here, it's important to pick out what the court can actually consider under the law and with the evidence presented, as opposed to this whole what's common practice, which has no real standing in law, or what other people have done in other cases, or what a speculative value of this case is. We heard Mr. Simon at times attempt an argument about the true value of this case, about that if it would have stayed at his firm, the case would have resolved in an amount closer to $700,000, just because some associate in a pre-litigation matter drafted a demand that set that number. That's all speculative. And yet again, in keeping with the theme of distracting the court from its true analysis and ignoring the quantum merit analysis, there's this speculation to try to invite the court to consider values and things that are really not proven here or have no bearing. And I know the Simon firm wants this court to add value to the case simply because Mr. Simon testified that in passing he would give strategy ideas or make mentions about cases, or yeah, we were colleagues, we worked together. But the truth of the matter is that under the quantum merit analysis that has to be made here, there's no room for the court to simply add on some arbitrary value and monies because of uncorroborated allegations. In fact, their own expert, Mr. Williams, said it's not proper for a court to consider work that's not actually done. And Mr. Simon's career, in his credit, has been long, his experience extensive, his reputation highly regarded. No one disputes that. But here, it is all irrelevant because his work on the file while at the firm, at the Simon firm, was minimal, if anything. So here, it's the position of the plaintiff that the court should only consider from the timesheets being alleged at this juncture, only the 2 entries that Mr. Simon individually billed for doing solo work on the file between the time I departed and then it was transferred to me. And that would equate to Mr. Simon's work being an hour, 0.2. And that lowers it, some. And I'm doing this demonstratively this way so that Your Honor can understand where I'm getting at this. I'm not just sitting here trying to divide it by months, trying to make it look reasonable. I've given this a lot of thought to be fair to everyone involved. And I want Your Honor to follow the exact numbers. As stated in my testimony, regarding the hours billed for myself and other associates, we have no objection. However, with regards to the emails billed, we adamantly dispute them. And that's a total of 11.4 hours at $4,980 that nobody knows what it's about. And according to the case law, and I provided this case law to Your Honor and counsel, in the Miller versus First American Bank and Trust, 607 Southern Reporter 483, it's a 4th DCA case. The case talks about
Southern Second.
Southern Second, yes.
Okay. Well, you just said Southern Reporter.
Sorry, Southern Second.
Okay, go ahead.
483.
I got it. Yeah, I had that part.
Okay. In the PDF I provided, it's around the second page, right-hand column. It states the court should review the nature of the services rendered and the necessity for their performance.
You said the PDF you provided today, or was it last time we were?
Last week, I provided your office, your chambers, with the case law that I was going to be referencing. But it's a short quote, and it's regarding that the case law is very clear that the court needs to consider the reasonableness of the charges. In fact, under the Florida bar rules, an attorney's ethical obligation to be reasonable when billing and to not knowingly add things it doesn't need to add. And
I interrupt you. Let me ask you a question, because on emails, it would seem to me that emails might be one of the more objectively provable issues with regard to attorney time. And in other words, if a lawyer is writing an email, and as we discussed the other day, the lowest increment of billing is 0.1. I mean, it would seem.
Your Honor, if I may, what my testimony was, and it's the evidence before you, is that in the Simon firm, it was not standard practice to use the email for anything substantive. And in Mr. Simon's testimony, he even agreed that the reconstruction of the hours came simply from the Needles client profile system, which doesn't house any emails in it. So all the tasks actually done were reflected in there and not in any emails. And in my experience, which I testified about in the other cases where emails have been exchanged, it's been purely clerical things. In fact, Mr. Williams' testimony, when he was asked about the emails, what he actually recollected from reviewing all these alleged emails was that it appears that it would prove that the emails were simply a vessel to communicate other things like photographs, which were already also being billed separately. So whether emails is a proper billing for an attorney and whether they could be substantive in nature, we don't dispute. The dispute here is that in this case, that hasn't been proven. And there's too much room for error, given that what we know you can bill for clerical things, we know you can bill for inter-office emails. In fact, there's 87 emails under my name. I have no idea. I had no personal opportunity to review that. And the question is, why weren't they presented to the court? Why weren't they put into evidence if it's such a big chunk of what's being claimed here? So that's why it's disputed, and it shouldn't be considered by Your Honor. And everything here tries to be minimal. oh, we're only billing 11.4 hours for it. But guess what? It adds up to almost $5,000. And Mr. Simon, we're only billing him at 11 hours. That's so minimal for a senior attorney who gave strategy when he was crossing the halls. You know, that's so minimal. But if you multiply it by the hourly they're suggesting, you're looking at 8,000 something, 9,000 something. So this is the theme of the Simon Trout firm. Present things in a way that they look reasonable and talk about these strategies. But as Your Honor said, you have to put blinders on and you have to look at it per the law. And the law says that the quantum merit analysis doesn't account for that. It doesn't allow for a calculation of that nature. So we have to look at what hours were truly proven and what the hourly rate. And it's our position that nothing of those emails was proven to be substantive work here, not by any of the testimonies given and not by the expert who actually reviewed the whole file. And now regarding the hourly rate, so as far as the presentation, if we look at the chart and we take away what the emails are, we're now at 31.45. And that's what we agree is reasonable as hours for the Simon firm. We're not disputing my attorney hours, and we're not disputing the associates. But Mr. Simon, the testimony has been clear and evident. No one said he didn't work at his firm. No one said he was a fat cat who sat around. He actually worked on 3 times the amount of cases with all the other 3 associates. That's why the caseload I had was strictly mine. He didn't also work on that. You're talking about an absurd amount of hours if he had to review everything I did on my cases. It's not reasonable. And there's no evidence before the court that it was done. In fact, the evidence of testimony before Your Honor is contrary to that. So with that, I want to move on to the hourly rates presented here and why we dispute the hourly rate for myself. Mr. Williams himself said that the court shouldn't focus on what other judges have found to be proper hourly rates in other hearings because we don't know.
Can I stop you for a minute? And I apologize to you.
Sure.
Before we move into that next phase of the argument, I just want to make sure I'm understanding. Basically, this is your lodestar spreadsheet, if you will, here. And right. So your number 26.2, which is the 34.9 less
emails.
And then his numbers are basically you're just agreeing to 1.2, and then with regard to TAB, and I can't remember his or her name, but
Tiffany, yes.
Exactly, Tiffany. You agree to the total 3.45, and then that number should be 0.6 because it eliminates the emails.
Correct.
And then SCJ was all emails, and that should be 0. Am I right on your position?
Yes.
Okay, go ahead. I'm sorry. You can pick up where you left off.
No, that's totally fine. And I do invite Your Honor to question as I go because it is quite tedious an analysis. I've put a lot of work into it, and I want to make sure that we're communicating correctly what our position is. So regarding the actual hourly rates, this should be attached to any one of these initials. It's our position that my hourly rate should be $275. And it's not because another court found it to be $275. Mr. Williams himself, when he was giving his testimony, he said that this court shouldn't focus on what other courts have found because we don't know what evidence was put before those courts. So we invite this court to focus only on what it's been before it. And what we know is that the Simon firm has failed to prove that my hourly rate should be anything higher than $275, which is what I actually charge, what I'm published at for charging. And if we accept Mr. Williams' own analysis as to how he got to the opinion of what the reasonable market value of an associate attorney's hourly rate is, which he said was based on the years of experience, strictly the years. He has no knowledge of my salary or wage earnings at the Simon firm. And he said that if the Simon firm is going to agree to bill the initials of SCJ, which is Ms. Stephanie Jimenez, at $275, and we must also bill my rate at the same level. As I confirmed in my testimony, and the Simon firm well knows this, Stephanie Jimenez is the same years as experience as me, and she graduated with me. So we do request that Your Honor consider my actual published rate of hourly work at $275 as what's proper here, and for all the other associates that have similar years of experience. Then with regards to Mr. Simon's hourly rate, we ask this court to consider Mr. Williams' testimony that the actual going rate in his community for an attorney with similar years of experience, doing similar, if not more complex work than Mr. Simon, is Mr. Williams' own rate of $500. Mr. Williams gave no other concrete documentation, couldn't even explain any study or research he's done in the community. He couldn't give an example of another attorney that does a similar type of personal injury work who has charged $800 an hour. So the evidence is void of any $800 an hour being reasonable. So that's why we ask this court to award Mr. Simon a $500 an hourly rate, which we think that is more than reasonable given the evidence and the going standard in the community. Now with this, we propose to the court, if we plug in, Your Honor, the hourly rate of $275 for myself and a $500 for Mr. Simon, and we keep the $275 that has been proposed for the other attorneys. This is how we get to the number of $8,918.75. So I just wanted to make sure I did it this way so that Your Honor can see how I got to that number, and it wasn't just a number in a vacuum. But this is what we believe is equitable, and this is what we believe should be awarded according to the quantum merit analysis. Which brings my court, my presentation to remind the court that its goal should be an equitable decision for all those involved. And in considering that, I'm going to put up this quote from the Mercy Hospital case.
Go back to your last chart that I was making.
Go ahead, Your Honor. I'll leave it up.
Hang in there for just a second, please.
Sure.
Okay, go ahead, Mr. Real.
Sure, Your Honor. Just in closing, the reason why we've talked about percentages and what's the percentage of what's being demanded here by the Simon firm is because not only, and this is the Mercy case, not only the reasonableness of the fees charged, but the appropriateness of the number of hours counsel engaged in performing the services as well as what the court needs to consider. The court should review the nature of the services rendered and the necessity along with the reasonableness of the charges. With that said, we ask the court to consider what attorney work on this matter actually contributed to the success of the case. And the Florida law requires this court to consider the beneficial results, if any, obtained in determining the reasonableness of attorney's fees. And the fee, and this quote is also from the Mercy Hospital case, says the fee awarded must bear a reasonable relationship to the results. As I testified in the work that I did subsequent to taking over the case, and it was depositions and hearings, many before Your Honor, I worked 78.5 hours. And that, in contrast to the hours of 31.45, which is what has been attested to or and agreed to as being reasonable in this case, is 71%, little more than 71% of the work to take this case from inception to a successful result. And we can't just look at the time it sat in an office. That's not the proper analysis here. In a totality of the circumstances, what this court needs to consider is what percentage of work what attorney did or what firm did. And with that in mind, it's also extremely important that this court consider the testimony I gave regarding my pay structure at the Simon firm.
Let me interrupt you. Legally, the argument you're making there would seem to be particularly apt if you were splitting the fee, but you're not. and do you see my point?
Yes, Your Honor, but the reason is that whether I split the fee with them or not. And I explained to this court that there is the occasion and there's a specific case that says my client can have an agreement with me that I can decide to reduce my fee depending on the results of any pen.
I'm back to my blinder metaphor. I'm really, if that's the law, and I'm presuming everyone's navigating their ethical obligations. It sounds to me like it's beyond what I really need to decide here. And but you're asking me to compare your work done to their work, and as a percentage of the fee, but your fee is 40% of 86. And you disagree about the numbers. Their number is what, 27 ballpark of
well, yeah.
That come out to, that's clear. So 6, a little more than that number, I guess, 31,000 or 31%, somewhere like that. Anyway, part of me is thinking out loud, and you.
And no, that's fair, Your Honor, and I do appreciate that they're great questions, and it's important that I do walk you through the analysis so you understand. The reason why I'm harping on what the success of the case is and what work it took is because the law requires us to consider what the Simon firm's hours put in, what's their reasonable relationship to the benefit it brought to the case. Because in all the cases regarding totality of the circumstances, don't necessarily say, like, just add value to things because, Mr. Rusomano was saying, well, in cases where there's been cause, then you have to deduct value as opposed to add value. You can't just add value for the sake of it. There's been no dispute of entitlement. There's been no dispute that the firm wasn't let go for cause. So if we're just considering what benefit the work the Simon firm did to get to the ultimate result, then it's important to understand that it's unreasonable for the firm to ask for such a large portion of what would be attorney's fees because it has no bearing on what the result of the case is or the facts of the case. So they could have just been a bad attorney overworking the file for no need at all. That doesn't mean that they're entitled to that whole amount. So I'll move on to the next slide I have here, which might help Your Honor in understanding the breakdown of what this client's net recovery really is. So we had the total settlement of the 86, 40% attorney's fees. In general, that's what the attorney's fees for, a litigation case is. And then it kind of breaks down to the cost that my firm incurred, the undisputed cost that the Simon firm is going to get, and then the plaintiff's outstanding medical bills. And that's the plaintiff's net recovery. Now, what's reasonable in a case is that, or what's unreasonable, is the position the Simon firm took. From an inception, it was demanding almost 96%. So even if that, in fact, would have come from the plaintiff's net recovery here, like when they're demanding it, because we're trying to negotiate something, it would be unreasonable in this case because it would highly prejudice the client and would leave her with no money. So we would have to dissect the hours being presented by the firm so it doesn't affect the client's net recovery.
But see, here's the problem I have with that is, and it might just be an insurmountable problem, is you don't want me to get in the middle of that, but you want me to consider it. And I don't mean you, I mean maybe the law. It just seems, like you want me to do what's fair, but it just seems like.
Well, unfortunately for a plaintiff,
my honest opinion, it's probably unfair the way the law sets this out. If I was on a blank slate, and I'm not so sure, the lawyers here would disagree with me, but that's just the way it is. And I'm just wondering whether,
exactly the sentiment I was going to say. I think it's an unfair law.
It seems to me like and that's with the greatest respect, of course, to the third DCA. It just seems, and I haven't read the opinion yet, so I probably shouldn't even form such a conclusion on that. But if what you're telling me is this is the way it has to be, that's the way it has to be. But I need to, the only reason I bring it up is your argument is basically saying it's read between the lines, and I could be wrong, and I don't want to put words in your mouth. So you tell me if I'm wrong, and you won't offend me. It's almost like, well, there's not going to be much money left for my client, and therefore they should take a smaller lien.
Well, right. That would be.
One might say, if I'm taking a global approach to the whole thing, one might say there's not going to be much money left for the client, so all the lawyers ought to take a lower fee.
Right, exactly. And I think that, unfortunately, we agree with Your Honor that the law doesn't seem fair to a plaintiff, like in these type of situations, but that's what invites the quantum merit analysis, because then, we get into, well, they still have to prove it hourly. And if we're just going to get into an analysis of splitting the fee between the attorneys, then that's why I wanted to show Your Honor what that would look like, because there is a case that talks about an attorney like myself with my client can have an agreement that my ultimate fee gets lowered by whatever adjudication is of the lien. But I can't agree to that to the inception, because if this court would then agree with the $33,000, it would leave my firm completely upside down or with no recovery. So it's an unfortunate and difficult situation. But in this case, it wasn't necessarily put into evidence or asked correctly if I would be willing to lower my fee to account for the Simon lien. But if that's the case, that's why we're focusing on a way to least prejudice the client. And that is by looking at what should be attorney's fees in this case as a whole, and who did what work, and what's reasonable to be demanded or not. And in this case, from the inception, the Simon firm has been demanding almost 96% of what attorney's fees are. So whether it was going to come from my fee or whether it's coming from the client, it would be unreasonable. We would have still been in this hearing at this juncture. And what I can tell Your Honor is that based on the information that the presentation we saw, this has been the same dispute in other liens with the same cast of characters, should I say, where the Simons firm is waiting to hear what the settlement amount is to then present and construct ours in a way where it's almost 40% of the of the total net recovery, gross recovery. So the only reason the Simon firm did not send us the charging lien amounts prior to knowing the settlement amount was to do exactly this. And I don't think that's a coincidence. I think it's all a calculated effort to try to garner itself a little bit higher value than what it really put in. And that's why I'm showing the court this breakdown. And if you see here on the evidence we saw, with based on the evidence, a star, the load star that I presented, what's feasible based on the hours we actually attested to and the hourly rates that the expert himself agreed to, it's the $8,918.75. If we consider the analysis that I'm saying about the totality of the circumstances of what firm did what work, and now we have to break down the attorney's fees. You're looking at the firm, Simon firm, doing 28.6% of the total work, and the Amanda firm doing 71.4%. And at maximum, then, what the Simon firm should get at maximum should be a pro rata equality of the work they put in.
Yeah, but when you say pro rata, we're talking about splitting up one pie, but we're not doing that. That was my point earlier.
Right. But in this case, there is, and like I was explaining to the court, there's an agreement that I will reduce my fee based on what the award is to the Simon firm, as long as it doesn't exceed. I'm sorry? That's
not for me, though. That's between you and your client, as you pointed out.
So, exactly. So I'm just pointing out to Your Honor, whatever split would have been, because it's trying to be said that that's prejudicial to the client, and that in this case, there hasn't been made efforts to try to resolve the matter. There has been. The demand from the Simon firm, and whichever analysis considered, has been unreasonable. And I've presented to Your Honor both analysis. And as you could see, the amounts, the theme here was to inflate the amounts and try to create, allegations to gain value in the case that were not corroborated. And none of it is based on reasoning or law and in the equity position Your Honor sits. And here, as far as the comments made that no expert was brought forward on the plaintiff's side, no expert is needed per the law, and that would have only been to incur unnecessary costs. based on the information given. And regarding the request for attorney's fees of Mr. Williams, we also oppose that the court grant those because it's our position that they did not need to bring an expert forward. And I've provided Your Honor the case law that actually just came out this year, indicating that it's not necessary that the firm have to present an expert. So that's an expense that they should incur on their own for bringing him forward. And with that, I conclude my presentation.
Thank you. Can I ask you one question though before I turn to Mr. Rusma? So, and I want to understand your percentages here and make sure I understand it. You got your fee is 40%, $34,400, and you're saying that I should award them. I'm looking at your bottom line here, 98.3840, but that's not what you were suggesting. Actually, the number above that is 89.18, and if I take 34. And because the math seems a little off to me. In other words, what I did, you tell me if I'm analyzing this wrong, I very well might be. You're saying that one of your arguments is that I should look at the allocation of the amount of the total attorney's fees. But if I give them 89.18 and you're taking 34.4, that and some change, it added up to 43.318. And then I divide 89.18 by 43.318. It comes up to, roughly 20%, not 28. Am I missing something?
The 98.38.
Where does that number come from?
That is based on the work. If we look back at this chart, which is the amount of hours put in by the Simon firm and the amount of hours put in by my firm after. So who had what percentage of beneficial results or put in work to that end result. That's what that is. And the arguments being made by the Simon firm that it's highly prejudicial and it's my fault that it's prejudicial, that the client's going to get prejudiced by paying 2 attorney's fees. And I say, well, okay, fine. If you don't like that analysis because you think it's so prejudicial, even if we conducted the analysis of where we're splitting an attorney's fee based on the law and based on who had what beneficial results to the settlement, then the Simon firm should end with 28.6% of what attorney's fees are.
Yeah, because but what's the number we're taking that percentage of?
From the total attorney's fees.
Yeah, but that's not my point. Is that's not the total attorney's fees. That's your attorney fee.
Right. Well, okay. Well, Your Honor, maybe I should back up and let you know that the maximum attorney's fees that the Simon firm could have claimed is up to whatever their contract amount was, which is 40%.
Yeah. Right.
Right.
But you're saying 28% of that fee, but then you were comparing it to your number and trying to come up with a total of 100%. I just, the math has got me a little confused, maybe through no fault of yours. But so let me just do that math then, if that's what you're saying, and let me see what that comes out to be. So if I take so 89.18 divided by 34.4 is 25.9%. So if you took, let's see, let me take, if that's your argument, or one of the things you're arguing, 0.028 point, let's see, 34. So if you took 28% of 34.4, that's $12,027.
No, Your Honor. I'm sorry. 12% of what?
The numbers you have down here in your chart, you're saying 28, they should have the 28% of the total attorney's fees.
Right, and 28.6% of the total of attorney's fees is $9,838.40.
And my point to you is how do you do that if it's 40% attorney fee is the total and it's 34.4 and I'm
multiply it times 0.286.
Yeah, I did that. I went 34.4 times 0.286 and I got $12,027.
I don't think that
34 times 0.286. I can't be right. 34.4. Let me just clear this off. My number was wrong. Hold on a second. Let me use a different calculator. Maybe this is my problem. $34,400 times 0.286 equals. You're correct. I'm wrong. I'm sorry. I apologize. It's 98.38 for you. I was doing. I don't know what my one calculator was doing.
It's okay. I know this is all
so
quite tedious.
98.38 is this bottom number. Then why do I have the top one? You're advocating for 89.18, but at the same time you're advocating for this 28.6% of the total fee, and it's 98.38.
It's our position that if the money is going to come from the client, which has been touted as a very prejudicial stance that I've taken, and you do the proper analysis of the timesheets with a proper application of hourly rates, the amount that the Simon firm should be getting is the $8,918.75. Now, if we take the approach that is a more logical, not prejudicial approach that the Simon firm is alleging that should be taken by attorneys as a common standard practice here, and we look at the work that the firm did versus the work my firm did as a totality of the circumstances, the Simon firm did 28.6% of the work. And that's, if it all came out from the same attorney's fees, that's what it would look like. So that's why Your Honor is getting kind of what at the lodestar analysis, the quantum merit would be if it's coming directly from the client. And if you were going to split the attorney's fees as to what's right and fair here, which is a compromise we've tried to reach many times, that's the maximum they should be getting. So that's the presentation that is before you.
Thank you. Russomano.
Very briefly, Your Honor, and if Ms. Real could please remove her.
Yeah, if you could, because I got it. I can't see my battery, and I'm hoping that my battery doesn't die here. So if you take that out.
Sure. Let me open Zoom here. Stop share screen.
I need to plug it in. I don't. Go ahead. Thank you.
Okay. Thank you, Your Honor. I'm going to very briefly, I wrote down some points that were discussed that I want to rebut. First of all, the percentage analysis that Mr. Real is proposing to the court is irrelevant. We know that. Your Honor's already hit the nail on the head. The case law Cersei. This is a charging lien case where the Supreme Court said that Your Honor must follow the Roe factors, which Mr. Williams testified to, and apply the totality of the circumstances. There is no analysis and no case law in which this court is to consider what percentages the client may or may not get, or what percentages Mr. Real may, after this hearing, decide to reduce. And the only testimony I heard from Mr. Real was that the client is going to be paying this fee. And I wrote down several things. Mr. Real says that she wants to do what's least prejudicial to the client. You heard from Mr. Simon that would have been the most least prejudicial thing to the client was for the client not to pay 2 attorney's fees. In every other plaintiff's firm, my firm's been doing plaintiff's work for 30 plus years. Usually you eat that fee if you take the case and you pay it out, but that's not what here. So we're in front of Your Honor, and Your Honor has to apply the law. And I could tell Your Honor that you look at LaBelle case is fine, but the two hearings we had before this, Judge Lopez and Judge Cinnamon in Miami, they put the blinders on as they must. And they gave Ms. Suriel her fee. It was the same scenario. She got her 40%. And then they said, we're going to rule on what the reasonable fee is under Cersei. Judge Lopez gave $42,000. Cinnamon $32,000, and Judge Lopez settled afterwards.
But I'm not even concerned with what I'm not overlaying her fee at all.
The reason for my point is I want to make sure that the standard that's applied is the standard that Your Honors to apply Cersei and render a ruling as to what's a reasonable amount. And there's nothing confusing. I wrote down confusing. There was nothing confusing about the submission. Amended Simon Exhibit 10 gives a detailed lodestar. And Mr. Williams, the expert, testified as to that as a reasonable amount. Rates and hours. Mr. Williams testified that the hourly rate of Mr. Simon is reasonable and the hourly rate of Mrs. Suriel is reasonable. In addition, the fact that there was no wild guesses and arbitrary, and the fact is the testimony of Ms. Suriel confirms she agrees to every hour she spent. So the only testimony that this court should consider on behalf of Mrs. Suriel as to any evidence as to what fees were incurred or not were her fees, and she agrees to every minute of it. So that's undisputed. Now it's going to be up to Your Honor to determine what the hourly rate is for Ms. Suriel. That's what this is going to come down to in the end. And the testimony is $475 on behalf of Mr. Williams.
Remind me of how he came to such a number.
My recollection of the testimony is that he came to such a number based upon her experience, her role in the firm, which Ms.
Very little, no offense, but I mean, she was a lawyer for less than 5 years.
I don't dispute how many years she was practicing. But Mr. Williams testified that based upon the role that she played in her, and again, there are some lawyers that have been practicing a long time that are not as good as lawyers as they've been practicing a few years. So it's the quality of the lawyer that should be applied. So Mr. Williams testified, and Mr. Simon did too, that Ms. Suriel is a fine attorney, and that based upon her role in the firm and the responsibilities she had, she was worth $475 an hour. And ultimately, it's going to be up to Your Honor to make that determination. That's what the testimony showed. And there is no expert on the I agree. We all know there's no obligation that the plaintiff have an expert to oppose Mr. Williams, but they have the right, and they chose not to. So there's no expert testimony in opposition. There's no evidence. They have no exhibits in evidence in opposition. Mr. Simon testified to the hours that were testified to. So there was no wild guessing. That was another quote that was used. The lodestar speaks squarely to it. I want to address the cases. Ms. Suriel addressed the Miller case. I asked, we exchanged case law before the hearing, Your Honor, last week, and she did give me the Miller case. And because she gave me the Miller case, I read it. And I want Your Honor to understand that Miller is highly distinguishable from this case. Why? In that case, they had over 20 people billing on that case. And the court found that 1,600 hours at $242,000 was unreasonable. Here, and I know I'm beating a dead horse, but I'm doing it on purpose. Here, the Simon firm is asking for 30 months of time of 1.75 hours per month. There is no case ever in which you could spend that little amount of time that could be deemed unreasonable. It's clearly reasonable, and it should be awarded based upon the hours that are almost stipulated to and the fees. In regard to the Miller case, it doesn't apply. Now, here's what I want to talk about this expert fee. Again, the case that the two cases on the expert, Mr. Williams under Treviso, Your Honor has the discretion to award the $6,500 for Mr. Williams. It's the Supreme Court. The two cases that Ms. Suriel just, she didn't give you names, but I read them anyway in preparation. The first case, the Robin Roshkin case, 4th DCA, that court gave the expert the fees. And I'm reading the holding. The expert testimony was required to establish reasonable attorney's fees. That's 4th DCA. Okay. And here's the interesting, the case that Ms. Suriel, she didn't name it, but I'm going to name it, that she said came out this year is the Law Office of Garnoff case out of the 3rd DCA. But here's what's interesting, and this is why it doesn't apply. In that case, the hourly rates and the hours incurred were stipulated. Okay. So therefore, I know we haven't had this hearing for 2 days now. We're not stipulating to anything. So that argument doesn't apply. As your honor is aware, the expert fees are universally reimbursed. We had to go all this way. And here's the important thing. I disclosed Mr. Williams as our expert in October of 2019. Never has Ms. Suriel emailed me, called me, had an in-person meeting or anything telling me, hey, Herman, let's just stipulate that the judge can make a ruling on fees and I don't need an expert. You don't need an expert. I don't need an expert. Let's stipulate. I would have loved that invitation. It never happened. So you can't come here now at the 11th hour and 59th minute and say, Judge, we shouldn't have had experts. If that was the case, you should have told me almost a year ago that we don't need experts, period. So the expert award of $6,500 should be awarded. Your Honor, 1.75 hours over 30 months is entirely reasonable under the Searcy case, which governs this issue. Whether or not the plaintiff is going to pay 2 fees, it is what it is. Unfortunately, Ms. Suriel is going to have to take 1 fee for her and 1 for the client. And Your Honor, we respectfully request that Your Honor enter an order awarding the Simon Law Firm its lodestar fee, which is identified in detail as exhibit amended, and award the $27,418.75 as a reasonable attorney fee for the charging name. Thank you, Your Honor.
Can you address one matter, Mr. Russomanno, that she is requesting, Ms. Suriel, that effectively the court completely delete any email time?
Yeah,
remind me of how you think you're entitled to that. She's saying we're all clerical, not substantive. I don't think I have any emails in evidence. What's your position on that argument?
Here's the issue. Emails are the most important thing in every case now. I get the most important orders from Your Honor and emails from Your Honor. Every filing is an email. You have to read every single email. Your Honor, she stipulated to all of her time, which includes emails.
No, I didn't. I'm sorry, I did not.
Ms. Suriel stipulated to the hours that are in the lodestar as to her time entered that we're submitting. I heard exactly that, which includes emails.
She seems to not agree. No, she just spent a lot of time telling me that she's agreeing to her time less the emails, basically.
All right, so what's her hourly rate that she's deducting with the emails? I didn't see that, and I didn't hear it in evidence.
It was in her sheet there. She wanted, she'll tell me if I'm wrong. Her argument was that get back to my notes here, is that she wanted 26, or she was agreeing to 26.2 hours at 275, and that's basically the time you had allocated to her less the emails, but at a lower rate, of course.
Okay, then here's my answer to Your Honor's question. Mr. Simon attested to the fact that his firm spent that time on the emails on behalf of everybody. And Mr. Simon testified to the importance of emails. And Mr. Williams also testified to the importance of every lawyer reviewing an interview. And Your Honor can use Your Honor's own experience, and I can tell you from my experience as a lawyer, every emails are more important than anything now. You have to review every email. And if you miss one, you're going to be in trouble. They're even in requests for admissions now in emails, where God forbid you miss an email, boom, your case is admitted after the 31st day, other than the exceptions. So it's imperative that every lawyer review emails, every paralegal review emails, which we're not even seeking that time. We waived it to make this hearing go faster. So we ask that Your Honor reimburse the firm for its time, emails inclusive. And again, we're not even talking about a lot of time. This is a nominal amount of time that should be awarded. So the fact that we're saying that 1.75 hours over 30 months is unreasonable is laughable. That's why I said in the opening statement in the first day of the hearing, and I'm not sure why we're fighting over this amount. If Ms. Suriel wants to challenge the $4.75 an hour that we think she's worth, and she thinks she's worth less, that's her position. But the hours shouldn't even be discussed. They should be awarded. And the hourly rate's going to be up to Your Honor whether $4.75 an hour for a 4 or 5 year lawyer is appropriate or not, based upon Mr. Williams' expert testimony.
But where, other than Mr. Williams testify, that's reasonable. Where did we come up with the number?
The number in the time, Mr. Simon testified that in their program, the emails are submitted and they're reduced to the timesheet. It's Exhibit 5 is in evidence.
I should have been clearer. I got you on the emails.
Oh.
The hourly rate of Ms. Suriel, you're seeking to attribute $475 an hour.
Right.
And I'm just wondering.
The same answer I gave to Your Honor briefly before is that based upon Ms. Suriel's experience as the lawyer that she is, based upon her role in the firm, based upon the responsibilities as a managing partner in the firm, Mr. Williams testified that he believed it was $475 an hour. And I don't want to repeat it, but another court has awarded that amount as well, which Your Honor is going to make your own decision on that issue. So that was the answer based upon that issue.
Okay. Last chance. Anybody else want to say anything else?
That other than to thank Your Honor for your time and detail and attention to this case on behalf of the Simon Trial Firm, and I'm sure on behalf of everybody, we greatly appreciate Your Honor's time.
Ms. Suriel, anything else?
No, likewise, I'd like to thank Your Honor and ask Your Honor to keep in mind the prejudice my client will be facing if unreasonable amounts are awarded in this matter.
Okay. No, I understand. Thank you very much. Thanks to all the lawyers. I really appreciate your efforts on the case.
Thank you, Your Honor. And I would like to take this one moment again, of course, to thank you for your time. And if the court so chooses to send us to mediation on the rest of the cases, or has it?
They're not mine. That's the problem.
I know, but you know,
maybe it's not a problem, but I just don't know that I have the jurisdiction to do that. I'm not going to rule on this moment. I mean, if you all, I'll give you my 2 cents for whatever I already did kind of earlier. Whatever, as a judge used to tell me quite often, for whatever use you want to make of it. I really think you all ought to have maybe some more global discussion before you end up doing 28 more of these. It just doesn't seem like a good use of a lot of talented lawyers' time, in my opinion. And, you know, that's just my thought. But I have jurisdiction over one case. You want me to send you to a mediator with that before I make a ruling? I'm not going to do it today, but I can. My thought is I'm going to make a ruling on this week and just send you an order. Do you all want to go to mediation or? No,
Your Honor. I don't think it's going to be useful, and I think it will just, continue to create expense for everyone involved.
Okay. No better mediator than you, Your Honor. You've got it all.
Call them the way you see them. That's what we'll do. Okay. Thank you very much. I've got everything I need. If I need further argument, I'll track you down. But I'm going to, and if I need an order from somebody, I'll let you know. But I think the issues are somewhat narrowed in a way, and I just have to make a couple of findings and then go with the final determination on it. So, all right. Thank you very much, and thanks to the reporter.
Thank you, Your Honor.
Thank you, Your Honor.
Thanks, Natalie. Bye, Amanda.
Bye, Ron.
Bye, everyone.
Be safe.
Mr. Hubbard? Mr. Hubbard, are you there? Are you looking for the court?